Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Advocates, they're definitely intelligent people that they regularly file cases before the court, but they should not misuse their authority or since they are called as officers of court, they should maintain the distance and they should maintain the decency and decorum also. So to sum up, I want to say that they should not misuse their authority in the court of law. This is what is held by the Delhi High Court. Justice Anup Kumar Mediritta, A.K. Mediritta, he pulled up an advocate for filing a case and for filing a private complaint under 156 clause 3 crpc claiming the investigation or claiming the probe by CBI. For what? This is important. Regarding the investigation of defective chappals supplied to him by Woodland Shoe Company. So does it require CBI probe? So this is the main problem. So friends, remember, during the year 2020, our advocate, who is claiming that he has got 31 years of practice in the Delhi High Court, he purchased a pair of shoes from Woodland Company. Fine, it's okay. But they were found to be defective. Then he made a complaint. He made an online complaint. No action. Normally, after prolonged communications only, the shoes were taken back and the repair was also not to his satisfaction. So therefore, he has approached the Karolbagh police station and he filed a complaint there. So who will take the complaint? They did not register any FIR because it's not a cognizable offense. Defective product. What is it? Ultimately, it goes to the Consumer Protection Act. He has to file a complaint before the district because the value may not be more than 5 to 6,000. So they have to find District Consumer Disputes Redressal Commission or DCDRC. Police will not take action. That he is an advocate, right? Since they have failed to register a case, he approached the Superintendent of Police, that is DCP Karolbagh, DCP North Zone, for redressal his grievance under section 154 clause 3 CRPC. You know, 154 CRPC means whenever any cognizable offense is reported before the police station, either in writing or oral, the SHO has to reduce it in writing and register an FIR. Suppose if he failed to register the case, then according to 154 clause 3, the applicant can send a copy to the Superintendent of Police, who himself will register the case if it is a cognizable offense and take up investigation, or if not, he will entrust the investigation to some others. So this is the procedure, yes, but no case registered. So this is the problem. Ultimately, he has approached the honorable court, local court, that is Metropolitan Court, and filed a private complaint under section 156 clause 3 CRPC. Yes, this is the procedure for filing private complaint, but no action. Ultimately, he approached the ADJ and sought a direction from the ADJ to register a case. Yes, the ADJ court gave directions. Therefore, basing on that, they have registered the case and normally, as usual, they have entrusted the matter to the police for investigation. So now the police they have taken up investigation, but there is inordinate delay in the settlement of the case or detection of the case and taking necessary action. Now he filed a petition before the Honorable Delhi High Court seeking investigation by CBI, stating that the inordinate delay in the probe and recovery of the property is a violation of his right to life under Article 21 of the Constitution of India. You know what is Article 21? The state should protect the life and liberty of each and every citizen, right? So please remember, state said, so in this connection, normally the High Court asked a report from the state, that is Delhi police. They said that So according to law, investigation is about to be completed, and normally they may be filing the charge sheet, but there is no necessity for CBI probe. So this is the case. Now the court, basing on the placing reliance on the very famous case, that is State of West Bengal versus Committee for Protection of the Democratic Rights. In this connection, it is very clearly stated that while giving the orders, the court should examine the case. So the order should be sparingly, cautiously, and in exceptional circumstances only they should decide to entrust the matter to the CBI. Is it necessary? So ultimately, already when the High Court directed, this man has withdrawn his earlier petition, and hence once again he has refiled the petition. So ultimately the court came to the conclusion that he is a litigation master and awarded costs rupees 10,000 and asked him no probe by the CBI. Let himself be satisfied with the investigation of the local police. That's all regarding the case. So what I want to tell you is, please hear. You may be an advocate, no doubt. You know the procedure of law. When you know the law, definitely when it is a defective product or when there is a deficiency in the service of Woodlands company, what you are supposed to do, you have to file a case before the competent authority, that is DCDRC, right? Okay. So without that, you have gone to the police station. They registered the FIR. They did not register the FIR. You have taken up that matter. Ultimately, so when the court directed, you have filed a file complaint. They are probing the matter. What is so urgency? After all, this was occurred in December 5th, 2020. 1 year. Normally, we may be knowing for theft case or for disposal of any cases, 3 years time is necessary. 3 years time is almost, it is a general time. So therefore, you should not be in a hurry, and that too, what for the CBI pros? So according to CBI is an organization which was established in the Special Protection Act, and they will take up the cases directed by the center or if required by the state, not by the individuals. It's not that important. So as an advocate, you should know your limits. If you cross your limits, this will be the result. Unnecessarily pulling up the advocate, imposing a fine of rupees 10,000 or so. So it's not correct. So please treat it as a lesson and don't resort to such activities. Thank you very much.